All right, guys. Sorry about that. I literally just walked in the house and came upstairs to turn this computer on. I've been in and out all day. My goodness. But how are you guys doing? Good evening.
Evening, doing well, and yourself?
I am pooped. It's been a busy day. Oh my goodness. Let's see. We're going to be talking about tonight. Let's see. We did screening the signer already, right? Let's see. Yeah, because we were talking about written statement, credible witnesses.
I think we thought that notarizing for minors. I think that was the last thing we covered, if I remember correctly.
Okay, let's see.
But in the Florida handbook section.
So we only did the notary appointment. We didn't do screening the signer.
1 second. We did the notary appointment. Yeah, we did that completely. Screening the signer. We did that because we were talking about the different forms of ID we can use to verify identification.
Yeah, we did. Notarizer for the blind. Okay. All right.
And we did go over like oaths and.
Okay, I just wanted to double check. So I'm like, no, we did not just do the first. Okay. All right.
We did both of them. We concluded with notarizing for minors. That was, I remember that.
Okay. Okay, cool. So tonight we're going to be talking about reviewing the document. Let me see who else came in here. I just want to make sure I give everybody the allowance to talk. Good evening. Welcome, everyone. Okay. So, reviewing the document. Okay, so we're going to do reviewing the document, and then we can go over Notary Act, because it looks like, I don't know, we may not be able to go over all of Notary Acts because it's kind of big.
Which ones did you guys say you already did? The notary appointment and which one?
And screening the signer.
Okay.
So we're going to talk about reviewing the document tonight, and then we'll try to do some of Notary Acts too. I know in some states you have more acts than others, so that's probably going to be a pretty big section. Okay. Let's see. All right, how many people do I got here? It's 9:05. I'm going to go ahead and get started. Okay. So we're going to be talking about reviewing the document tonight. So let's see. So I think for all of the states, this would be common sense. We are not to notarize any incomplete documents, right? And it does have here for Florida, do not notarize. Florida notaries are specifically prohibited from notarizing a signature on a document that is incomplete. Any blanks in a document could be filled in by the signer. If the blanks are inapplicable and intended to be left unfilled, the signer should be asked to line through each space using ink or to write non-applicable or NA. Now, does anybody have anything different for their reviewing the document? Before you notarize the document, you know that you have to review it to make sure that it's complete, right? We all should be doing that. And then too, looking to make sure there are no pages missing, right? Like at the bottom of the page, sometimes they have numbers, sometimes they don't. So obviously if it doesn't have any numbers, it'll be difficult for us to notice if there's any pages missing, right? So we just have to trust the signer on that. But if you do have page numbers, it's really important that you look and make sure that you have all pages. Now, what is considered disqualifying interest? Okay. Here for Florida, it says impartiality. Notaries are appointed by the state to be impartial impartial, disinterested witnesses whose screening duties help ensure the integrity of important legal and commercial transactions. Lack of impartiality by a notary throws doubt on the integrity and lawfulness of any transaction. A notary must never notarize his or her own signature or notarize in a transaction in which the notary has a financial or beneficial interest. Does everyone understand what impartiality is when it comes to having a disqualifying interest in the document being notarized?
I understand that.
Yes.
Okay. Can you give me an example of when you would be considered impartial to a document and you should not notarize it?
Family.
Yeah.
Like if you're doing a document for your family, you can benefit from it. You should not be signing that.
Correct. But what about when you are notarizing for a stranger? You can also become could also have impartiality if, because you explained a document a certain way, then they decided to sign it instead of letting them rely on their own understanding of the document. Do we know that?
Yeah.
Yes, but I thought we weren't supposed to explain documents anyways because we're just verifying signatures.
You're right. But just because that's the rule doesn't mean it's always followed.
Gotcha.
Some people will, well, I done drove all this way. I need you to sign this document. This is basically what it means. Oh, okay. And then they sign it. Yeah, that's not being impartial at that point. Now, we all know what financial and beneficial interest is, right? If we stand to get anything other than a fee for notarization, then we will be having a beneficial or financial interest in the document. So we shouldn't be notarizing that. Now, they have exceptions here. Let's see if every state has the same exceptions. So for Florida, it says a notary who notarizes for an employer that receives a benefit from a transaction is not considered to have a disqualifying interest unless, he or she receives a benefit other than his or her salary and the statutory fee for notarization. Is there anyone in the group that notarizes for an employer? No? Okay. Well, that's easy. Let me see. Do I have a new person in? No, I don't. Okay. All right. Now let's see. For Florida, in addition, a notary who is an attorney does not have a disqualifying interest in notarizing the signature of a client unless he or she is a party to or named in the document. Any challenged case of disqualifying financial or beneficial interest would be decided in court on its own merits. Thus, it is always safest for a notary to have no financial or beneficial interest whatsoever in a transaction, regardless of what the law allows. Do we have any attorneys in the group?
I'm not an attorney, but I have a question.
Sure.
So if, say, you're notarizing for a law firm and they don't have, I think I might have asked you this before. I'm sorry if I did. And they don't have witnesses and they witness for the client, would that be, what's the word we're using right now? It's in their financial interest because they're the attorney who is, drawing up the papers at their law firm, but they serve as a witness for their client?
So if they are listed in the document, then they cannot be a witness for that document. If they're listed anywhere in the document, they're the attorney in the case, then most likely they're going to have their name on the document, right? So no, they cannot be a witness to that same document.
Okay. Thank you.
Mm-hmm. Now, refusal of services. Let's see here. Now, in Florida, it says legal requests for services. Ideally, as officers appointed to serve the general public. Notaries should honor all lawful and reasonable requests to notarize, regardless of the signer's client or non-client status and without discrimination or personal bias. However, the governor's notary section has opined that it is not unlawful to discrimination for an employee notary to limit service to the customers of a notary's employer or to transactions that are solely related to the business purposes of the notary's employer during the notary's normal working hours. So I don't know what that means.
I was just gonna ask you to break that down for me.
Yeah. Let's see. I'm going to read it again. You know, sometimes if you read things more than once, it's like, oh, okay. So let's see.
Well, it sounds like it's saying that you can only refuse to do notarizations during work hours if you are a notary for the company you work for. No one else got that. Is it just me? That's what it sounded like to me.
Hold on, let me read it again. Limit service to customers. I don't know. So then I was thinking refusal of services. Oh, okay. So it's basically saying just because you work for the employer does not mean that you cannot refuse to notarize a document, especially if you see that it doesn't meet the requirements that are needed for you to notarize a document. Like just because you work for them doesn't mean, well, you got to notarize this document because you work for me. No, that document's incorrect. I'm not notarizing it like that.
Right. But that's only doing work hours, right? Because after work hours, your stamp is yours. I mean, it's yours, period. But outside of work hours, it's just yours. So that's kind of contradictory because we're not supposed to refuse service anyways, unless it's within those parameters.
Well, it's just saying that just because they're your employer, they can't just bring anything to you, whether it's work related or not, and say, I need you to notarize this. If it doesn't meet the requirements, should you do that?
Right.
Just because
No.
you work for them? Absolutely not.
No.
So it's not unlawful for you to refuse services. I have somebody raise their hand. Teresa, did you have a question? Oh,
Can you hear me
you were
now?
just telling me to unmute you. Yes, I can hear you now. Sorry.
That's fine. I was trying to answer other questions from the previous, and I couldn't. It didn't show the different parts, so I can unmute myself. But I'm good.
Okay.
I'm good now. Thank you.
Okay, you're welcome. Let me see. Can I? There we go. Okay. How do I get back to attendees though? Oh, clear this. Okay, there we go. Okay, you know what? Because I didn't scroll down enough and I didn't see you, Teresa. I apologize. I try to make sure everybody's unmuted. Let's see.
Your face is not on the screen anymore. If that
And I don't know. It keeps saying we have done some optimizations to improve audio quality. I don't know. I do. There we go. I keep having to click the button. I'm sorry.
that's I can see you now. Okay.
Okay. All right. So yeah. So everybody understand refusal of services.
Yes.
Okay.
Yes.
Moving on, we're going to be talking about wheels now. So the do not offer advice. We're just kind of talking about that with the impartiality, right? When it comes to certain documents, you have, if they don't understand what they're signing, then they need to have the person who's drawing up the document to have them explain, because we cannot explain a document to get them to understand, because if you are doing all of that, then you're no longer being an impartial party, you know? All right, so let me read for Florida here for wills. Often people attempt to draw up wills without benefit of legal counsel and then bring these homemade testaments to a notary to have them quote unquote legalized, expecting the notary to know how to proceed. In advising or assisting such persons, the notary risks prosecution for the unauthorized practice of law. The notary's ill-informed advice may do considerable damage to the affairs of the signer. Does that make sense to everyone?
Yes.
That's
And it
basically
happens a
just a
lot
longer,
for me, and I was going to ask if it happens a lot for y'all, but it's like people always be like, well, I'm not sure how I'm supposed to fill this out, so what do I do? And I'm like, I don't practice law, like you're going to have to seek legal counsel. And they're like, well, but aren't you a notary? Yes, but that's not what I do. And I feel like I constantly tell people that I can't
Yeah.
explain to them what's going on, and they get upset.
Mm-hmm. Yeah. And you're going to get that a lot because people, they put more on our responsibilities than what it really is. It's like, we're supposed to, authenticate the signature. Authenticating the signature, meaning that we are identifying the person is who they say they are, and this is their signature on the document. And that's really it. That's it. We don't do anything else. So, and if you explain it to them, they get upset. They just get upset. But, like I try to tell people at the end of the day, my commission is not worth your document. What's going on here? I'm not, it's not. It's just not. All right. Anybody else have any specific rules in their primer for their state for wills? What is it saying for you? Anything different than what I just read? No? Okay. Oh, wait, somebody just messaged. Hold on. Go back. Okay. Nope, that wasn't me. Okay. Authority. And this is for Florida. A Florida notary may notarize a will, whether prepared by an attorney or not, provided the following conditions are met. The document signer is present and appears to understand the purpose of the document. The signer is personally known or is able to produce acceptable identification. The signer may not be identified by credible witnesses. You see how important it is? When it comes to wills, they cannot be identified by credible witnesses. So we cannot use that identification method. It can only be personally known or produce acceptable identification. Anybody else have anything different for their state when it comes to notarizing a will?
Are you just reading out of your handbook or?
Mm-hmm.
Okay.
Yes, we all should be looking in here. If you have your state primer, or if you have a U.S. reference book, or if you have an actual PDF download from your state Secretary of State website. Everybody should have something available so that we can compare and contrast the different allowances for our states.
Just trying to figure out this, Teresa from Ohio.
Okay.
Exactly where you're located, where you're at in your book.
Yes, I'm in Florida.
I'm sorry. Where you about in your book?
Oh, so I can't tell. I can tell you the page, but it's not going to be the same page in your primer, most likely. But I'm on.
Is it under
wills?
Yep. It's under wheels. Like, can you guys see this?
I have the wheels. Okay.
Okay. And then on the second page here, I have, I'm under authority right here. Mm-hmm. It's right after wheels.
I'm in Florida and my page doesn't even look like yours.
That's what I'm saying. All of them are different.
Did you get the Florida primer for the NNA?
I did.
Yes, it came with my certification.
Yeah, because the one that you have, Virgil, is the older version.
I know.
It's the same information. To be honest, it's the same wording. It's just if they like update or page or two, it just sets it off a little bit.
Yes, I agree. Because when I show people this, they're like, "What? I'm in Florida. Mine doesn't look like that." Yeah, I got mine.
Your cover is cooler than ours, though. Like, it looks like legit.
Well, I was commissioned in July of 2020, so I don't know if that makes a difference. Maybe they dropped a new one after that. I don't know.
Yeah, because I got mine April 2021.
Okay. All right. Okay. And then let me see. The last point under authority here says the document contains pre-printed jurat wording, or the document signer must direct the notary to provide a jurat. So this is in the case of if somebody prepared their own will and it doesn't have any certificate wording, you still have to ask them what type they want. We still can't tell them which one, even though it's saying here the signer must. It says the signer must direct the notary to provide a jurat. So you're still going to explain to them the differences. Okay, the difference between acknowledgement and jurat. We can't tell them which one to choose, and we can't just attach our own because we know it should be a jurat.
I have a question about the wills.
Mhm.
When a person does come with, these wills that you can either buy like Office Depot or Staples or whatever, and they fill out everything as they should, and of course you just notarize the signatures. I'm kind of curious as to what would happen in the case that the will is needed, and I mean, as a notary, your information is on there, but something is wrong. But how do I say this? Will you be penalized as a notary if something wasn't documented correctly in the will?
No, our job is not to make sure that the will is filled out correctly. Our job is to make sure that the will is complete. You will be penalized for notarizing an incomplete document. What if it was incomplete and then they didn't do anything to fix it? You just notarized it as is. You could have some responsibility on that part. But remember, our job is just to witness signatures. We're identifying the person who's going to be applying the signatures, and we're witnessing them sign the document. Okay. And that's it. And then for the jurat, making sure that you administer that oath. That's super important, because if you don't administer the oath, the transaction is not valid for a jurat.
Okay.
Now, I wanted to know, though, before we move on, does anyone have a different identification requirement for wills than what I read for Florida? Are you not able as well to not use credible witness? Do you have to only use personally known or acceptable identification? Or can you use a credible witness? I'm curious to know in a different state.
I don't see anything in Texas about witnesses or credible witnesses.
For the will?
For the
Yes.
will.
For wills authority?
I don't see anything about authority.
Okay. Are you also looking in your state primer? Or do you have like a...
But for Texas, correct.
Okay. So I don't know how it would look in you guys' books, but in my book, it has wills here on this page. And then on the next page at the top is where authority came from. So it's right up under the wheels, because it's continuing to talk about the wheels. Do you have anything that's talking about
Under
wheels?
wills,
Mhm.
all I have is do not proceed without certificate wording, and then
Okay.
living wills, and then it goes straight into immigration.
Oh, wow.
So
Okay.
in Ohio, it does say, it has the wills, and then the next page is notarial acts, and then it has authorized acts.
Oh, wow. So it just skips that part for you guys, huh?
Yeah.
Okay.
Connecticut as well.
Really? Gosh. Okay. Well, then I guess it's safe to assume that whatever your allowed identification methods are, you can use that for wills too. Now, what I will say, guys, is even though we have this primer, you should still look at the handbook that's on your Secretary of State website if you have one. Okay. There's nothing wrong with comparing them, because sometimes what's on the state website will be a little different from what you see in this primer. All right. Next, we have notary and witness on same document. Now, this is for Florida, providing that the document does not require the notarization of the witness's signature, the notary may be one of the two witnesses as well as the notary public on the same document. Does anybody have a difference for their state? Can you be a notary can you be a witness and a notary on the same document?
Wait, for a will, I'm sorry. For a will, let me get my timer back out. I'm multitasking, y'all. I'm trying to cook.
Okay.
I know it's super late. So we can be a witness for a will as the notary who's signing the document?
Yes, the notary in Florida, the notary can be a witness on the same document. Now, it is cautioned that for wills, though, we do not serve as the notary and witness on the same document.
Right, that's what I thought. Okay,
Yeah.
but we can. We
But
just
can.
Okay.
Yeah. Mm-hmm. Does any other state have a difference where it says specifically you cannot be a witness and the notary on the same document?
Nothing in Texas about it.
So you can be. It doesn't say that you can't be.
It says nothing about it.
Oh goodness. Okay. Any other state?
Ohio just says additional witness required for certain documents must
Mm,
be acknowledged to be valid and recorded. For example, deed, mortgage, and land land installments contract.
okay. So then it sounds like you cannot be a witness on the document you're notarizing.
Yes.
Okay. All right. Now for Texas, I would, if you have if your state does have a handbook on the website, I would look at that.
Okay, thank you.
Not unless you know otherwise. Like, do you know that you can't?
No, I do not know. That's why I'm on this
Oh.
call.
Oh, all right. Well, make sure you guys are taking notes, like for things that you're not finding in the
Mhm.
book. Make sure you taking notes so that you can look back on your state handbook, because I would definitely like to know what it would be for your state.
Yeah, thanks.
Yeah, you're welcome. All right, self-proving wills. So for Florida, it says typically self-proving wills shorten and simplify the probate process. A will or codicil, amendment to a will is what that is, may be self-proved before a notary at the time of its execution, testator and witnesses taking an oath and signing an affidavit stating they signed the will in the presence of each other. The notary is responsible for administering an oath to the testator and witnesses and for completing the jurat. The notary should complete a certificate in substantially the following form. Now it says here, it shows here that we have in Florida, we have a certificate that we can use for self-proving wills. That's one of the cool things I like about Florida. You don't have to worry about, well, what certificate should I use for that type of situation? They have one that we can use. Okay. So for Florida, we do have a certificate, and I didn't share the link in the regular group. It's only in my student group, but I will share the link in the support group, because I think I shared it before, but it may have been a couple of years ago, so it's probably lost in the feed. So I'll make sure I share it again. The link is notaryflorida.com, and then you would click on the resources tab, and they have all type of certificates that we can download and use for different situations. Okay, and they're free. It's not like with the internet you have to pay for it. You have to like pay for a membership to have access to the loose certificates, right? Well, with notaryflorida.com, they're all free for Florida notaries, so you don't have to pay for
Please
anything.
share that with us, because I did not even know that existed.
Yes. Let me see. I could type it here. It's notaryflorida.com. And then you want to click the resources tab.
I thought the only forms that were there for Florida was what's on the NNA website. I didn't know there were other ones.
Nope. We have them in other places too. They probably don't want us to know that we can find them in other places.
No, of course not, because then a lot of people won't keep their membership. That's why I have mine.
Yeah.
And then I can't even, it's not even easy if I'm trying to like send it like Bluetooth from my phone to my printer. It won't let me click on the links because it's from my phone. And for a while I was like, why is this not working? I pay you guys for this. And come to find out, I have to be on a computer to click on those certificate links to print them.
Oh, yeah.
So I
Yeah.
can print from my phone from NNA to my printer.
Yeah,
Oh.
let's print certain ones, but not all of them. Like the acknowledgement I can print with no problem. The jurat, I always have to do it from the computer because I had to call them to find out what was going on. And they were like, oh, you have to use it from your computer sometimes. And I was like, oh, okay.
Oh, okay. Well, yeah, definitely check out that website. When I tell you it has, oh my God, you're going to be like, oh my God, this is the mother lode of certificates. It has everything. Yeah. So definitely check it out.
Yeah.
All right, let's see. Now, witnesses. Okay. It says Florida law provides that any competent person may act as a witness to a will. Ideally, the witness should be impartial and have no financial or beneficial interest in the person's estate or the document being presented.
Mm.
And everybody said they don't have anything else about witnesses, right? Just to be sure.
Yeah, nothing in Texas.
What about Ohio?
I'm still looking.
Okay. All right. Now it says here living wills.
Subpoena of witnesses. That's probably something else.
No, yes. So for this part, it's just saying basically who can be a witness
Okay.
to a will, right? So any competent person, but you definitely want to make sure they don't have any financial or beneficial interest in the person's estate or the document being presented. So like if they're listed in the document as getting anything in the will, then obviously they can't be a witness to the document.
Correct. Yeah.
All right. Now we have living wills. For Florida, it says documents that are popularly called living wills may be notarized. These are not actually wills at all, but written statements of the signer's wishes concerning medical treatment in the event that the person has an illness or injury and is unable to issue instructions on his or her own behalf. So I think they have that there just to tell you the difference between a will and a living will. One is for while you're alive, the other one's for when you pass. All right. Now, we have the unauthorized practice of law. I think for the most part, we all understand that, right? If you're not an attorney, you don't want to give legal advice or accept fees for legal advice. For example, I had a person call me and ask me if I can notarize her retirement plan because she wanted to state that her daughter gets all of her retirement or something, like her 401k, I guess, or whatever, after she passes on. And so I told her, I said, I can notarize that for you, but I do have to let you know that that is not going to be legally binding. I think that you should definitely seek an attorney so that you can make sure that what you're doing is the right way to do it. Only because I would hate to notarize this for you and then you pass and then it comes down to she's not getting that. And then that would just make me feel bad, like, and so she was like, oh, okay. I just thought that if you notarized it would be legal. And so I explained to her, no, it would not make it legal. So I don't know if she contacted another notary to just notarize it for her, or if she actually did go to an attorney, but that wasn't me giving her legal advice. That was just me giving her like, like I can do it for you, but just let me just explain to you that that's not what's going to happen. Does that make sense?
That's very interesting. I've never heard that before.
What?
Having to notarize a 401k. I thought if you have the person listed as a beneficiary, whatever happens to you goes to them.
Yeah, but see, I couldn't tell her that, right?
Right.
My thing was, just telling her that me notarizing it is not going to do what it is she's trying to do, and for her to just seek legal counsel, pretty much. And so she thanked me, because a lot of people are not going to do that. Some people are going to be like, all right, whatever, you want to notarize, but that on my conscience, like, can you imagine them being in court? Well, my mom got this notarized. Okay, well, because she didn't list you as a beneficiary, nobody gets anything.
Right.
I mean, I would feel I would just be devastated. Like, she would probably call me like, my mom's gone now, and nope, I don't want that on my. I'm like, nope, I am not going to notarize that for you. I'm sorry. So don't be afraid to, do that, guys. It's not giving them legal advice, but it's just telling them, I can notarize it for you, but it's not going to do what you want it to do. Now, if she would have said, well, I don't care, I still want you to do it, then you still can refuse, but if they understood and you did notarize for them, what I would do is put it in my notes. Signer explained that this notarization would not make her document legal. Like, I would just cover myself, because if for some reason, they were very upset and they wanted to put it all on you, at least you got documentation. Because when she write those notes and you have her sign your journal, she's signing that she understood, right?
Right.
So just cover yourself. I personally wouldn't do it, but if you would do, just cover yourself. That's all I'm saying.
CYA.
Right. Now let's see. Exceptions. All right, let's see what Florida is saying for exceptions of unauthorized practice of law. It says non-attorney notary certified or licensed in a particular field, that being real estate, insurance, or escrow, may offer advice in that field. Paralegals under the supervision, of an attorney may advise others about documents in routine legal manners. So if you are a notary who also holds a license in these particular fields, you can give advice regarding these particular fields, but not any other. Like, does that make sense? Like, I shouldn't be, if I am a notary for real estate and I'm giving insurance advice, that's not authorized. It's unauthorized, right? And the same will go for the other ones too. Like, if I'm in escrow, but I'm giving real estate advice, like, it's just saying if you're not licensed in it, don't give advice for it. Okay, stay in your lane. Is that what it's called? Stay in your lane of expertise.
Yep.
All right.
Yes.
All right. The next is authentication. Does everybody know what authentication is for your state? That is talking about apostles. An apostle is an authentication of a document that's required by the state, the competent state person who's allowed to do that, pretty much. So for the most part, it's the Secretary of State or the Department of State. Okay.
Okay, really quick. In the unauthorized practice of law. So I've been seeing in a lot of different groups, notaries talking about preparing documents. So I'm assuming that they have training as document preparers, which is why they are preparing these documents and selling them.
Yeah. So if you have the appropriate licensure or credentials to prepare documents, then yes, you can. But for those people who are not able to produce that evidence, they may get in trouble. I don't know. I don't have that. Oh my goodness, guys, my cat. Hold on. Nope. No. I don't prepare, so I don't know, but I'm assuming there is some type of credentialing process that you can go through to be able to prepare documents. Like, what if the notary is a paralegal?
Right.
You know, like you don't know what extra licensures or credentials they hold.
Yeah, that's what I was assuming, but because I hadn't seen anything about that being something that notaries can do. But I know different states have different things, and I've seen it a couple times in some groups. So I was like, oh, maybe it's a thing.
Okay. Yeah, absolutely. All right. So authentications, okay? This is for Florida. Documents sent out of state. Okay. So documents notarized in Florida and sent to other states may be required to bear proof that the notary signature and seal are genuine and that the notary had authority to act at the time of notarization. So that's pretty much what an apostle is. When you guys have a document and the person's asking you to notarize it, and it's not going to be used in the same state, it may require additional authentications. Okay. But this is usually for documents that are going outside the country, not so much as being used in a different state. Hold on, guys, a second. All right. Okay. So, where did I leave off? This process of proving the genuineness of an official signature and seal is called authentication or legalization. In Florida, the proof is in the form of an authenticating certificate attached to the notarized document by the Department of State. These certificates are known by different names: certificates of authority, certificates of capacity, certificates of authenticity, certificates of proto-notary, and flags. An authenticating certificate from the Florida Secretary of State costs $10. It is not the notary's responsibility to pick up or pay for the certificate of authority. To obtain a certificate of authority, the document signer must submit by mail a written request with the notarized document, a self-addressed stamped envelope if the documents to be returned by mail and a check or money order payable to Department of State. And it has the address here for Florida. Has anyone in the group ever been asked to do apostle or obtain an apostle for someone?
Not in Ohio.
Oh,
What about Texas?
No.
No? Okay. I've done them a few times here in Florida.
I'm interested to learn more about that.
It's really it's not a hard process. It is a few steps that you have to take before you can just tell a person, yeah, you can do that for them. But it's really not hard. It's not. You just want to follow the steps on your Secretary of State website. Because remember, anybody can do it. You don't have to be a notary to request an apostle. So just go on the website and read what it says for authentication in your state. Now here, for Florida, it says documents sent out of country. If the notarized document is going outside the United States, a chain authentication process may be necessary, and additional certificates of authority may have to be obtained from the U.S. Department of State in Washington, D.C., a foreign embassy in Washington, D.C., and a Ministry of Foreign Affairs in the particular foreign nation. Apostles and the Hague Convention. Fortunately, over 100 nations, including the United States, subscribed to a treaty. Oh, really? No. My cat done slapped my hand because I'm telling her no. Oh my goodness. Subscribe to a treaty that simplifies authentication of notarized documents exchanged between any of the nations. The official name of this treaty, adopted by the conference on October 5th, 1961, is the Hague Convention, abolishing the requirement of legalization for foreign public documents. Okay. And for a list of subscribing countries, they have a website that you can visit here in our primer. You guys see that? So as long as the country the document is going to is on the list of the Hague Convention, then you can just obtain the apostle from your Secretary of State. But if the document is going to a country that, is not a part of the Hague Convention, then you need to submit the request to the Department of State, which is located in Washington, D.C. Does anybody else have anything different for their authentication process in their state?
Nothing about that in Texas, other than the first paragraph.
That's the same thing you read in Ohio.
Say it again for Ohio.
I said what you just read. I have the same thing in my book.
Oh, okay. All right. Video went off. All right. Now, here it says foreign languages. Foreign language documents. So Florida notaries are not expressly prohibited from notarizing non-English documents. As long as the notary certificate and document signature are in English or in a language the notary can read, Florida notaries may notarize foreign language documents. However, there are difficulties to consider with foreign language documents. Blatant fraud might go undetected. The U.S. notary seal might be misinterpreted in another country, and making a journal entry might be difficult. Okay, so for us here in Florida, they are saying that we can notarize foreign language documents, but the certificate has to be in English, and the person signing the document, they need to be signing the document in the English Roman letters that we know. Does anybody have any difference in their state?
Nothing for Connecticut.
Nothing about foreign languages? What about the authentication in Connecticut?
Authentication, yes.
Okay.
I just had it, yeah.
Okay. All right. Now, foreign language signers. For Florida, there should always be direct communication between the notary and document signer, whether in English or another language. The notary should never rely upon an intermediary or interpreter to determine a signer's willingness or awareness. A third party may have reasons to misrepresent the transaction to the notary and or to the signer. Specifically, Florida law prohibits a notary from notarizing for a signer who does not speak or understand the English language unless the nature and effect of the document is translated into a language that the signer understands. Anybody have any differences for your state as far as foreign language signers go?
In Ohio, it says ideally a foreign language document should be referred to to a notary who reads that language. In many states, the website of the notary regulating official has a notary directory. These directories often include foreign languages. That's not really what you said, though.
Okay.
Texas is the same as Ohio in this case.
Ohio.
Okay.
Oh, somebody else is on here from Ohio?
No, I think she said Texas.
Oh, gotcha. Okay.
Yeah. So basically, they're all saying the same thing, just differently. But basically, if you can't understand them, they can't understand you. You need to refer them to somebody who can speak their language.
Because it says if she cannot read, the notary certificate should be in English or in language the notary can read. Signature be notarized. The signature that being notarized should be written in character the notary is familiar with.
Mm-hmm. Okay, good. Now it says immigration. Naturalization certificates. This is for Florida. A notary may only photocopy a certificate of naturalization for lawful purposes. The NNA recommends that a notary only certify a copy of the certificate if written directions are provided by a U.S. immigration authority. Has anybody ever been asked to certify a photocopy of a naturalization certificate?
All I know is, as a naturalized citizen, when I had my green card and I made a photocopy of it, I was stopped at the border and was threatened with detaining or removal.
Whoa.
Because I had a photocopy of my green card.
Oh, wow.
Subject to deportation.
Oh, man. Okay. Well, then we know. And then it does say here, only certify a copy if written directions are provided by the U.S. Immigration Authority itself. So we have to be very careful with that, guys. If that's something you can do, because I know not all states allow copy certification as an act for you. Okay. We're at the end of this one. So it says advertising. False or misleading advertising. A notary's commission can be suspended if the notary uses false or misleading advertising to misrepresent the authority, rights, and privileges of a notary. For example, a notary who represents himself or herself to be an immigration expert and who leads clients to believe that he or she has powers beyond that of a Florida notary is guilty of false advertising. Then it has here for Florida also foreign language advertising. A non-attorney notary advertising notary services in a foreign language must take steps to guard against misinterpretation of his or her authorized function. Notaries are required to include in any such foreign language advertisement the following statement in English and in the foreign language. I am not an attorney licensed to practice law in the state of Florida, and I may not give legal advice or accept fees for legal advice. And then the translation of notary public. Literal translation of notary public into a language other than English is prohibited by law. So everyone has, I'm pretty sure everyone has that advertising restriction in their book, right?
I'm trying to find it in mine.
Yes.
Okay. Mine was under immigration in my book. It has advertising.
May not advertise or suggest in any manner.
All right. And that's it for reviewing the documents. So that did take us to 10 o'clock. Wow. So I guess we're going to have to wait to do Notary Acts because Notary Acts is pretty thick, especially especially because we don't do a whole lot here in Florida, but I know for some states you guys do like way more than we can. So, oh my goodness, yeah. So next Sunday we are going to have to talk about Notary Acts. Then, okay. How'd you guys feel about tonight's review?
I really appreciate it and enjoyed it.
All
So
right,
I just
cool.
really appreciate
Great.
you doing this for us.
I did too.
Thanks
All
so
right,
much.
good.
I'll
Okay,
be
you're
quite
welcome.
honest, if
I
it
took
weren't for you, I probably wouldn't have gone through this book so detailed.
Really?
No.
Oh wow. Well, I'm glad that you guys joined. Like I said, I got 37 people who signed up, and how many I have here? 6. So I guess not everybody wants to go over the review as they thought, but it's okay. It's okay. I am recording. I didn't post the other recording because I wanted to make sure that I had permission from you guys to post. Are you guys okay with me posting recording in the group?
Please, I thought maybe I was tripping because I couldn't find it, and I was like,
Oh.
she said she was going to post it, but I don't see it.
Yeah, I forgot to get permission at first. I don't want to be posting it and somebody be like, you know what? I didn't think you were going to post that, and I didn't really want, so I have to be respectful of that. So I will post tonight's and last Sunday's recording in the group for you guys. And then did everybody for Florida, did you get the Notary Florida link? The certificate?
I have bookmarked it. Thank you.
Okay, you're welcome. And for those of you who didn't have, no, you're not on my bed. Oh, I'm about to get my squirt bottle. For those of you who did not have the same thing in your book as I did, please do the research on your Secretary of State website if it's there, and let me know what you found. I'm very curious to know what the answer is to some of the things that we talked about. Okay.
Yeah, I did some parking lot questions so I can, give you the answers when I find them, if I find them.
Yes. Yes. Okay. Awesome. Thank you so much. Yes, please do. All right, guys. So I will see you next Sunday. You guys have a good night.
Thank you so much. You
You
too.
You're
too.
welcome.
Thank you.
You're welcome. Bye.
Bye bye now.
Bye. Good night, everyone.
Good night.
Good night.